Hello, I'm Harriet Isaacson, and I will be your instructor for the next 3 hours. I look forward to sharing information with you on working with buyers. That really is working with or for buyers, for we always have to address the Alabama law on RECAD and how it does affect how we work with or for those buyers. Let's look at our goals for this session. We want to be able to enable everyone that's taking the course to identify the steps in working with the buyer to find property that really meets their needs. And then we also, as our objectives, need to be able to explain caveat emptor to the buyer. If you think about it, Alabama is the only true caveat emptor state in the whole United States. Now, some other states have partial caveat emptor, but every time that there is a court case and the judge or the courts are ruling in favor of these sellers in most cases, as saying it is up to the buyer to go ahead and satisfy themselves as to the property conditions. So caveat emptor is very important to explain to anyone that you're working with. We also need to briefly explain the different types of agency and RECAD the buyer. Tell them about the law of agency that we have in the state of Alabama. Apply good communication skills. Our business is centered around good communication skills, and how successful we are depends on how we communicate. Explain steps in buying a property. Some people have never bought a property before, and they need to have an explanation. Some people have bought property in other states. It doesn't work exactly the same. Think about it. Even in another city in your state, it is different the way that we do buy a property. There's a lot of the same things that will apply, but there's a little difference there, so we need to know what they are. Apply fair housing and antitrust laws when working with or for the buyers. And we also need to be able to explain property inspections and why it is so essential that the buyers secure a home inspection and satisfy themselves about the property conditions before they ever go to the closing table and close out. Explain the steps of financing and stress the importance of getting pre-approved early on. Why? Think about it. You don't want to go ahead and show people property that is in a higher price range than they can afford. You would be wasting their time, and you would be wasting your time too. So getting them pre-approved early on is so important. Also, we'll be able to explain how the licensee will write a clear and concise offer when buyers decide on the right property, and then explain how the licensee will calculate a buyer's estimated closing cost sheet at the time that you're writing the offer. All of these things we're going to be looking at in this course today. When working with the buyers, one of the important things that we must know, what are your office policies? Does your office represent buyers? Does your office represent sellers? Do they do transaction brokerage? Do they do sub-agency? This is what we're talking about. Is there going to be agency or non-agency? So we must know what our company does go ahead and have in their office policy. What is your office standard of care? How does your office perceive that you should treat each person, each consumer that you come in contact with? There's office policies on this. And then another thing that we have to think about is our risk management, because every day that we get up, we are having a lot of risk, and we need to know how to manage those risks. So we'll be looking at some of these things today too, but it's very important for you to know what your office policy does say about agency or non-agency, standard of care, and risk management. Now let's think first of all about RECAD disclosure. We know that it's an Alabama state law, and we must disclose the law of agency or RECAD. Now, when do we do this? Well, the law says as soon as possible. That is not very defining, is it? It doesn't tell us exactly when. So that is left up to us when we have the opportunity, the first opportunity that we have. Let me give you an example. Let's say that you're at an open house on Sunday. Someone comes into your open house. They're a potential buyer, and they are looking at this house and they start asking questions. Well, actually, you do not have time at that particular moment, possibly, to disclose RECAD because of the fact that you've got 3 or 4 other couples in the house looking at the same time. So getting together with them at your office or after the open house is over and going ahead and explaining RECAD, the Alabama state law, about how we can work for them or with them. And this is very important for us to do. We would use the mandatory disclosure form and ask them to sign that form saying that we have disclosed to them the different types of agency or non-agency that we have in the state of Alabama. We would also, at the time that we are going ahead with the RECAD disclosure, present the buyer agency agreement to them, go over the buyer agency agreement with them, and ask them to sign the buyer agency. Do they sign it right then? Some will and some won't. But we have at least explained it to them at the time that we have disclosed RECAD to them. Now, with RECAD disclosure, we are going ahead and disclosing about the possibility of dual agency. Is there going to be a conflict? It could be. If you think about it, dual agency can bring about a lot of conflicts, but disclosed dual agency is what we have to do. Disclosed dual agency is perfectly legal in the state of Alabama. And we have given the informed consent. We have gotten the informed consent from this buyer that we can do disclosed dual agency if they so allow us to. They may decide that they do not want to participate in disclosed dual agency, and we could only show them property that is listed by another firm where we would not get into disclosed dual agency. Now, another thing that we have to think about, let's say that you are a buyer's agent. And when you're a buyer's agent, you are having the responsibility of imputed knowledge. Your knowledge of a leaking basement is imputed or assumed to your buyer clients. Makes it very important for you to go ahead and disclose to your buyer clients what you know about that property, right? Think about that. And then imputed notice or assumed notice. Let's think about that. Communicating an acceptance of buyer's offer to the buyer's agent is the very same thing as communicating acceptance to the offeror. If you think about this, that is very, very important. Let me give you an example. Suppose that you have an offer from some buyer clients. The buyer clients have made this offer and it has been accepted on the basis of a contingency to sell their property that they now live in. Maybe it has a 24 or 48-hour break clause. And the property is going to remain on the market while the seller of this property is trying to find another buyer that would, and the buyer offers them a contract offer that would be acceptable to them. And then this 48 hours notice would kick in. Well, if you're a buyer's agent, the listing agent has notified you that there is another acceptable offer that the sellers are going to take if your buyers do not remove their contingency on selling their house within 48 hours. All right, let's think about that situation. You have received the notice. That's imputed notice. So it's the very same as if your buyer clients have received that notice. Maybe your buyer clients have gone on a cruise and you cannot get in touch with them. 48 hours passes. And then the buyer clients that you are working for have lost the house because they did not remove the contingency on selling their house. They didn't even know about it, but you knew about it. So it's so important for us to say to those buyer clients, don't go out of town. Don't get into any situation where I can't be in contact with you, because I might have a very short time that I have to get in touch with you and let you know that we would have to go ahead and remove this contingency on selling your house, or it will be that the sellers will be able to sell to someone else. So imputed notice is assumed notice, and that is given to you as the buyer's agent, and it's a big responsibility that you know how to get in touch with those buyers at any time. Think about this. Let's reflect a little bit on imputed notice. It's very important that you communicate this to your buyers at the time that you are working with them to write that offer. And it also is important for you to be able to stay in touch with those buyers. Know how to communicate. Communicate by email. Keep a copy. That is so important for you to do, because once you have communicated by email, you have let them know. And you communicate by fax, keep a copy. Keep a copy of the confirmation of the transmittal. And then follow up with a telephone call to your buyers. You're going to make every effort that you possibly can to make sure that the buyers have the notice that has been given to you, because it's coming through you, and it gives you a great responsibility when you are a buyer's agent. Now let's talk about some risk management when we're a buyer's agent also. This applies when you're a buyer's agent or a transaction broker, but keeping good records is so important. Paper trails are of the utmost importance. If you think about it, chronological notes of showings, activities, conversations, anything that could apply to this particular transaction. We must adhere to all the time restraints in the contract, getting extensions of provisions as necessary, and never let a contract expire, but extend it before the expiration date. Paper trails are of utmost importance, not only for you to be able to check back whenever there's any question, but if there should have to be any kind of legal action in the future, then you have got your good paper trails that will help you tremendously. We have been told by leading attorneys that you should have your files in such a good order that if there is a lawsuit of any sort or any kind of legal action, then you would be able to turn that file over to an attorney, and they would be able to know exactly what the transaction had been, how it had progressed. And you would have your notes in such good order that they would be able to follow you all the way through. Well, I'm going to ask you, are your files in that good a condition? I would say very few people's files are in that good condition. I know mine are not, but it's something we have to strive for. We have to make sure that we have our files in good condition and that they would be in a stage that people would be able to interpret them. NAR's policy on agency disclosure goes right along with the state law that we have on agency disclosures. NAR's policy says that it must be timely. We said as soon as possible in the Alabama state law, didn't we? NAR's policy says it must be meaningful. It has substance to it. It is something that you have been able to explain to the buyers so that they understood what they were signing. Do they always understand what they're signing? I think not. It is a situation a lot of times that they sign just because you ask them to. So let's be sure that we communicate in such a way that they truly understand what they have signed. Now I'm going to take you back to imputed knowledge and imputed notice. Do you know that a lot of your forms are written in such a way that it says the very same thing that we have already addressed, that notice to you is the same thing as notice to the clients. Did the clients understand that? It was written, wasn't it? NAR's policy says it must be written, and we say that it must be written when we have an agency relationship with the buyers or an agency relationship with the sellers, but here we're talking about buyers. So it must be meaningful in that they understand what they're signing and that it is in written form. If you have taken the time to communicate in 2 or 3 different ways the same message, then you're sure that they understand. Or ask them questions. Does that make sense, Mr. and Mrs. Buyer? Is that okay with you? And then you will find out if they have questions or if they're just signing because you ask them to sign.